court calls the matter of Wagner versus Wagner, case number 2020-6371 DM. All parties and attorneys can please state their name and appearance for the record, starting with the plaintiff's attorney, Mr. Norg.
Thank you, Judge. Good morning. Attorney Benjamin Norg on behalf of Bradley Wagner.
And good morning, Your Honor. Kimberly Schroeder appearing with and on behalf of the defendant, Christy Wagner, who is also present by video.
Good morning, everyone. Today's date and time set for a hearing. This matter is being done by remote technology due to decisions of the Supreme Court and Chief Judge. The contents of this video may be the official record of a proceeding of the state of Michigan's 9th Judicial Circuit. Unauthorized duplication, distribution, alteration of said content is strictly prohibited. Today's date and time set for a motion to set aside the default. Counsel, where are we at with this matter?
We would like our motion to be granted, please.
Okay. Mr. Norg, I saw your appearance. I didn't see a response. What is your client's position on the motion to set aside the default?
Thank you, Judge. Yes, I was just retained last week. I had not had a time yet to respond to this. Orally, Your Honor, I suggest that the motion should be denied. The default was entered, and in it was joint custody. I know that the major contention, if I can recall, is the parenting schedule is different from the prior agreement, but that was a prior agreement back from 2019, and in the default, it said something different, right? Week on, week off, and she had an opportunity to dispute that then, chose not to. She was properly served. I asked the motion be denied.
Yeah, Ms. Schroeder, it's your motion, so I'll give you the last word briefly.
Thank you, Your Honor. Mr. Wagner has unilaterally changed what the party's agreement was for parenting time, and Ms. Wagner has not had an opportunity to dispute that default judgment. We just received a copy of it 2 weeks ago from court staff, and she does not agree to those proposed provisions. I also don't know how the child support was calculated, and there's things that I think need to be done properly in this case.
Okay. Motion for today was properly noticed out. Looking at the court rule, MCR 2.603, which gives the parameters for which we can set aside default. Basically, we look at opportunities of fairness and what prejudice and where we're at with these matters. Should Ms. Wagner have relied on a written statement? Most people would say yes. Did she know that if she had that written statement, she probably should have answered the divorce anyway and made sure it was done properly in court? It's easy for a judge or a lawyer to say yes, because we do this every day. For a lay person, they think they have an agreement. I'm not going to let a family matter go to a civil court to dispute the contract law of the previous agreement. There is no prejudice to set aside the default. It's not a game of gotcha. I have a feeling Ms. Wagner will never do anything in a court of law without consulting an attorney anymore. Not because she's not intelligent. It's just she doesn't understand how court works. I don't understand how brain surgery works. So it doesn't mean anything against her. It's just now I think she's learned. I don't see any prejudice to Mr. Wagner. Yeah, maybe she should have answered, but I think in her mind she had an agreement and we're going to follow the agreement. But that wasn't an agreement that was in a court order at the time. So I will allow the motion to set aside the default to be granted. And Mr. Wagner should know, and so does Mr. Norg. I and probably most of my colleagues grant these about 80 to 90% of the time. Usually it's a mistake made or a misunderstanding. This case is still early enough that I want to make sure that an independent person, not the parents, because there's already finger pointing as to something is not trustworthy. I want to make sure what's best interest of the child. So I will grant the motion to set aside default. I do believe that based on its filing, the filing, what's laid out in the filing is presentable to be set aside default. I'm not going to set it for a separate hearing to have the mother go through each and every line. Even in Mr. Norg's defense of it is they had an agreement. but it sounds like it's not being followed. So I will grant the motion to set aside the default, and we'll get this matter set to go through the system appropriately. My staff indicates to me that they will do the order and they will get a new trial or hearing date. I think it's probably next be set for pretrial, then possibly mediation. I encourage the parties to work towards a settlement. It sounds like they had an agreement. If that's changed, then each side can go to trial, but if they can come to an agreement, that's best for both of them and their child. I encourage that rather than to have the court system do it, but it'll be put in a court order. So therefore, if there's any changes that are going to be made, they cannot be done unilaterally. They'll have to be done through the court system. Any questions by anybody?
Oh, Your
No,
Honor.
thank you.
Best of luck. All prior orders not affected by today remain in effect.